The Reynolds family has made it clear that they've taken a genuine liking to her, and that support has meant everything. She has often spoken about how grateful she is for their kindness and authenticity, saying she couldn't imagine having anyone better in her corner. That strong backing is especially important now because Blake Lively is facing mounting pressure in court, and the fear that her entire case could be thrown out is beginning to show in her filings. Late last night, her attorney submitted a new request that reveals just how worried she has become. After previously moving for treble damages under California Civil Code 47.1, her team has now filed an opposition asking the court to deny Wayfair's motion for judgment on the pleadings on the grounds that it is untimely, and failing that, to grant her nearly a month-long extension to respond. At first glance, her filing looks like a full opposition to Wayfair's motion, but when examined closely, it isn't quite that. The very first thing she asks for is denial based on timeliness, while also making a backup request for more time. Her lawyers argue that she is prepared to answer every argument raised by Wayfair, whether at the summary judgment stage or even trial, but insists that Wayfair deliberately waited nearly 9 months to file this motion, and timed it so that her team would be overwhelmed with depositions during the response window. They claim this was a tactical maneuver designed to burden both her and the court. The filing suggests that Wayfair's arguments could have been raised much earlier, that they are based on fact issues rather than legal issues, and that briefing them now would create unnecessary duplication with summary judgment proceedings that are just around the corner. But here's the problem. The claim that Wayfair's filing was late does not hold much water. A motion for judgment on the pleadings is only permitted once the pleadings are closed. Blake Lively herself admitted in the same filing that she had to submit multiple complaints. Her first on December 31st, her second on February 18th, and a second amended complaint on July 30th, 2025. The defendants then had 2 weeks to respond by mid-August, and her reply would have followed shortly after. That means Wayfair's timing was actually proper, and their motion arrived only about 6 weeks after their answer. By rule, a judgment on the pleadings cannot be filed before the pleadings close, and it is fundamentally different from both a motion to dismiss and a motion for summary judgment. Lively's attempt to characterize the filing as untimely is therefore shaky. Her lawyers also attempt to poke holes in Wayfair's pleadings by pointing to what they call sloppiness. In a footnote, they accuse Wayfair of improperly raising arguments that depend on an affirmative defense regarding exhaustion under Title VII, even though that defense was not pleaded in their answer. They argue that if anyone is entitled to judgment on that issue, it would be Blake herself, not Wayfair. They also insist that she amended her CRD complaint and obtained a right to sue letter during the pendency of this action, which would resolve that exhaustion issue. But this claim raises its own questions. Through prior FOIA requests, copies of her original California Civil Rights Department complaint were obtained, and it showed that the CRD closed her case the very same day it was filed. Once closed, such a case cannot simply be amended. It requires a brand new filing. If she really did amend it, the timing is suspicious. If she just updated it after filing this latest motion, that would be well beyond the 300-day window required after the alleged harassment. And if she failed to provide that updated right to sue notice to Wayfair, that is her responsibility, not theirs. Wayfair even included as an attachment in their filings the CRD complaint that Blake herself gave them during discovery. For her to claim now that she amended it is questionable at best. Her attorneys spend much of the filing trying to persuade the judge that considering Wayfair's motion now would be a waste of time, since the same issues could be litigated at summary judgment, when all of the evidence is available. They argue that summary judgment is the proper stage for fact-based disputes, because it allows both sides to bring in evidence such as depositions, text messages, contracts, or other documentation to support their positions. They even suggest that Wayfair will suffer no prejudice if their motion is pushed off until then, since purely legal issues will not be affected. But this argument undercuts itself. If Wayfair's motion truly raises only legal issues, then there is no need to wait. Pleading challenges are not supposed to turn on evidence. By conceding that those legal issues could just as easily be heard now, Blake's team has weakened their own claim that the motion is improper. What becomes clear is that Blake is frustrated by the limits placed on her case. Discovery has closed, which means she can no longer inject new evidence or reframe her claims through amended pleadings. Yet she continues to argue as though she has fresh material that will help her. The reality is that once discovery ends, you have to litigate with what you have. Her filings read less like strong legal arguments and more like an effort to delay, deflect, and buy time. She claims Wayfair's filing is untimely, but the record shows it was properly brought after the close of pleadings. She claims she amended her CRD complaint, but the documentation suggests otherwise. She claims that Wayfair's arguments should be reserved for summary judgment, but simultaneously acknowledges that many of them are purely legal. The contradictions are piling up. At bottom, what this shows is that Blake Lively is worried that her case could collapse if the judge agrees with Wayfair. Her filings are increasingly defensive and her strategies increasingly strained. The judge now has to decide whether to indulge her request for denial and delay or to move forward with Wayfair's motion on the merits. And while her attorneys are doing everything they can to paint this as unfair timing and gamesmanship, the underlying record suggests that Wayfair acted within the rules. If the court accepts that, then her motion may not just fail, but it could accelerate the unraveling of her case. On one hand, Blake Lively's team is telling the judge that Wayfair's motion for judgment on the pleadings has no merit, no grounds, and should not even be entertained. Yet on the other hand, they argue that even if the motion is delayed until summary judgment, Wayfair will still be able to raise the same arguments then. The problem with that reasoning is simple. If the issue is about the pleadings, then it belongs at this stage. A pleading issue does not need to wait until summary judgment, because summary judgment is meant for disputes involving evidence gathered during discovery, things like deposition testimony, documents, text messages, contracts, or video evidence. And of course, both sides are almost certain to seek summary judgment later, which is standard. But here, the defense is pointing out that the defects are legal in nature, not factual. Lively, however, insists she now has additional evidence that she would like to bring in, even suggesting she might amend her complaint again. But discovery has already closed. Fact discovery officially concluded on September 30th, meaning that phase is over except for a few lingering depositions, and the case is now moving into expert discovery. What frustrates her is that she no longer has the ability to expand the record, yet she continues to hint at new evidence that she claims supports her claims. The truth is, what she really wants is to reopen the door on a case that is procedurally locked down. Her filings also reveal a larger strategic problem. She brought her case to New York federal court, even though her right to sue letter was issued by the California Civil Rights Department. A California right to sue letter only authorizes filing in California, not New York or New Jersey. By choosing the wrong venue, she left herself exposed to arguments that her Fair Employment and Housing Act claims cannot apply extraterritorially. Wayfair argues this is a matter of law, not fact, and therefore appropriate for resolution on the pleadings. Her suggestion that this should be pushed to summary judgment makes little sense, since whether a California statute applies outside of California is not something additional evidence can change. It is a purely legal determination. She also attacks Wayfair's timing, arguing that the motion was filed on September 26th and therefore was excessively delayed. But the federal rules state that a motion for judgment on the pleadings can only be filed once the pleadings are closed, and so long as it does not delay trial. Here, trial is currently set for March 9th, 2026, a remarkably quick turnaround for a case of this size. In federal litigation, especially one involving numerous defendants and extensive discovery, trial dates are often pushed back more than once. In that context, a motion filed 6 weeks after the answer is not excessive delay, but rather well within the ordinary window. Refusing to consider it now could actually waste time and taxpayer resources if the case proceeds to trial only for claims to later be found legally insufficient. Her argument that Wayfair's challenges are fact-bound is also misleading. The core issues they raise, extraterritorial application of California's FEHA, fair report privilege, litigation privilege, and the collapse of her civil conspiracy claims if the other claims fail, are legal matters, not factual ones. These are not questions of disputed evidence, but questions of law, and therefore squarely within the scope of Rule 12c. Her filings, however, try to obscure this by suggesting that Wayfair is simply rehashing factual disputes. Perhaps most telling is her suggestion that if the court accepts any of Wayfair's arguments, she should be granted leave to amend yet again, because she has more evidence now. That request signals weakness, not strength. If the pleadings themselves are legally defective, it does not matter how much evidence she has uncovered. Those claims cannot move forward. And if the court allowed another amendment, it would reopen discovery, dragging the case out even longer. Courts are reluctant to allow endless amendments, particularly after multiple prior attempts. The law requires that claims be legally viable on their face before discovery can even be considered. In effect, Blake's filings amount to an admission that she cannot win on the law alone and needs evidence to save her case. But that is not how the rules work. Legal sufficiency must come first. If the claims are not legally permitted, no amount of evidence will cure them. To accept her position would be akin to allowing Wayfair to say, "Our case was dismissed on legal grounds, but now we've found new evidence, so please reopen it." She would never tolerate such a maneuver from the defense, yet she expects the court to indulge her. Her argument that she will suffer significant prejudice from having to respond while discovery is ongoing also rings hollow. Throughout this litigation, she has repeatedly filed sanctions motions, attorney's fees requests, and procedural challenges that have forced the defendants to divert resources and respond on short deadlines. For her now to claim that a routine motion is overly burdensome ignores the fact that she has used the docket aggressively to try to pressure the defendants. Moreover, when you are litigating, it is always possible that a motion on the pleadings will be filed, just as it is possible to face a pending motion to dismiss even during discovery. That is part of the process. At the end of the day, her claims about timing, delay, and prejudice lack teeth. The court has every reason to hear Wayfair's motion now, since it raises purely legal challenges that go to the heart of whether her claims can even proceed. By trying to push those issues off to summary judgment, Blake is signaling not confidence in her case but desperation to keep it alive for as long as possible. Legal battle surrounding Blake Lively has taken another fascinating turn, and this chapter of the story reveals more about courtroom tactics, procedural maneuvers, and the ongoing back and forth between her team and the defense. What's happening right now is a tug of war, not just over facts, but over legal standards, deadlines, and even the judge's patience. Let's unpack all of this in detail, because the deeper you look into it, the clearer it becomes that this is not just about Hollywood drama. It's also about how the law works when someone tries to stretch it beyond its proper reach. So here's the scene. Blake's team is pressing the judge to flat out deny a motion against her without really addressing the substance of the motion itself. Instead of carefully countering each legal point, they're asking the court to reject it as untimely and let things keep rolling forward. But at the same time, they hedge their bet by saying, well, if you don't deny it, at least give us more time to respond. That's a strategic stall. They want to delay the real fight until later, when more evidence is in play, but that creates its own problems. The defense sees right through this. They know she doesn't want to answer the hard questions about whether her claims are even valid under the law. One of the key issues is whether the Fair Employment and Housing Act, or FEHA, applies outside California. And the reality is, it doesn't. Yet Blake is trying to argue that she should be allowed to proceed anyway, even though none of the events happened in California. And even though the proper venue for such a claim would have been a California state court, not federal court in New York, that's a huge hurdle and she knows it. Instead of addressing that directly, she focuses on accusing the defense of making false claims about administrative exhaustion. In other words, she says they're wrong to argue she didn't properly file her right to sue letter. But here's the kicker. I looked into the records for the It Ends With Us production, and the defense isn't just pulling things out of thin air. Even though the company says it's based in California, they actually opened a branch in New Jersey. And New Jersey even gave them massive subsidies, $12 million worth, to film there. The production then generated more than $34 million in revenue for the local government and community. The jobs, the contracts, the filming, all of it was centered in New Jersey, not California. That fact alone makes it incredibly hard for Blake to argue that California's FEHA should cover her claims. None of the relevant conduct happened there. So even if she got a California right to sue letter, it doesn't travel with her across the country. She can't just take it to New York federal court and say, see, this covers me. The law doesn't work that way, and the defense is hammering that point hard. But what's Blake's move here? She wants the judge to say, don't even bother looking at these arguments, it's too late, they waited until September to file. Yet the reality is, timing alone isn't enough to save her. Courts look at whether hearing a motion would actually delay trial or prejudice one side. And here, the defense is arguing that addressing the pleadings now actually saves time and money. Think about it. If you let a legally defective case limp all the way to trial, you waste everyone's time, resources, and taxpayers' money. A motion for judgment on the pleadings is specifically designed to prevent that. It's not about facts. It's about whether the claims are legally valid on their face. Blake's argument that she'll be prejudiced if the court hears this motion now is pretty hollow. Why? Because she has already filed endless motions herself that have slowed the case down. Motions for sanctions, motions for attorney's fees, repeated attempts to force the judge to act on issues he hasn't ruled on yet. Every one of those required the defense to stop what they were doing and respond. She can't now turn around and claim that she's the one being unfairly burdened. The irony is thick here. She's saying, "I'll suffer prejudice if I have to answer this motion while discovery is still ongoing." But motions to dismiss and motions on pleadings happen all the time while discovery is underway. That's part of the process. And the defense is right to point out that her claims don't survive on legal grounds alone. Evidence won't fix that. Even if she uncovers 10,000 documents in discovery, if the claim isn't legally permitted, it doesn't matter. You can't just amend endlessly every time you find a new piece of evidence. Yet that's exactly what she's trying to do. She's basically telling the court, if you strike down some of my claims, just give me permission to amend my complaint again. But she's already filed a second amended complaint. If she really had this so-called evidence, she should have included it then. She didn't. That tells us she doesn't have what she claims. And even if she did, the evidence doesn't prove retaliation unless it's connected to her employment. And here's the catch. She wasn't even employed by It Ends With Us when some of the things she's pointing to happened, like the premiere in August 2024. By then, her contract was over. Retaliation law requires that you were still an employee when the retaliation occurred. Without that, the claim fails. Now, let's pause and look at how the judge is handling this because it's telling. At first, he set a deadline for Wayfair to respond. But then he changed course. Instead of letting this play out on paper with letters flying back and forth, he said, "Enough. We're not doing this dance. I want you in my court." So he ordered a video conference hearing on October 3rd at 2 p.m. via Microsoft Teams. And here's the important part. He's allowing public and press access via audio dial-in. That means full transparency. This decision cuts right through Blake's attempt to frame the defense motion as a delay tactic. If it were just about delay, the judge could have brushed it aside. Instead, by scheduling a hearing so quickly, he's signaling that the issues raised are serious enough to warrant immediate attention. And what are those issues? Whether she exhausted her administrative remedies under FEHA, whether she even has standing to sue, and whether her retaliation claims are properly pled. Those are foundational questions. If the answer is no, the case could collapse. Blake wanted the judge to just deny the motion outright as untimely, without considering the merits. But the judge isn't playing that game. He sees the bigger picture. He knows he can't just brush off arguments that cut to the core of whether this case should even exist. By holding a hearing, he ensures both sides have to argue this in real time under his questioning. No shortcuts. No hiding behind motions. And that's huge. Because now Blake's attorneys can't just throw in language about prejudice and untimely filings and hope it sticks. They're going to have to stand in front of the judge and answer the tough questions. Did she file the right claim in the right jurisdiction? Does FEHA apply to conduct outside California? Did she properly allege retaliation while still being employed? Those are black and white legal questions. They don't get solved by new evidence or emotional appeals. They get solved by the law. So where does this leave us? The defense has set the stage by arguing that Blake's case is fatally flawed from the start. Blake is scrambling to keep it alive by saying, "I have evidence, I just need more time." But the evidence doesn't matter if the law says she can't bring the claim. The judge is cutting through her delay tactics by scheduling a fast hearing, ensuring this gets resolved quickly. And the public will get to listen in, which adds even more pressure. At the end of the day, Blake's strategy looks less like a strong legal position and more like an attempt to buy time and shift the narrative. But time is running out. October 3rd is around the corner, and when that hearing happens, the judge will have to decide whether her case can even move forward. And if he rules that her claims fail at the pleading stage, no amount of evidence will save her. So what do you think? Is Blake trying to stretch the law to cover ground it doesn't? Is she hoping the judge will bend rules just to keep her case alive? Or is there some hidden strategy here that could turn things around for her? Let me know in the comments below, and as always, don't forget to like this video, subscribe if you haven't already, and click the bell so you never miss an update. This case is moving fast, and the October 3rd hearing could be explosive. Thanks so much for watching, besties!